There are a lot of new presumptive service-connected conditions that are about to be passed into law in the Honoring Our Pact Act. And in a previous video, I talked about what those conditions were, and I also mentioned how the effective dates for these are going to be spread out over time. In this video, what I want to get into is some of the things you can do to deal with those effective dates. So the first thing you can do is just file your claim and wait. The PACT Act specifically prohibits the VA from denying your claim just because the presumptive service-connected condition won't take effect until into the future. So we're probably going to see a lot of decisions where it says you're granted service connection on an effective date out into the future. That'll be a little bit weird, but it's the law. Now, as usual, to prove you have one of these presumptive service-connected conditions, you have to prove you're one of the veterans who's covered by that presumption, which usually means you have to prove you have the disability and prove that you were in the right place at the right time. And you should be able to do that pretty easily right now, even though, again, the presumption won't take effect off into the future. There are some interesting implications to filing a claim for disability benefits, getting a favorable decision, but that decision not being effective for potentially years into the future. And one of the first ones that probably comes to mind is the idea that this is going to bog the system down. And to be fair, it probably will. Maybe not as bad as some people think, but it will have some effect on the system for sure. I think the best way to balance that is to wait until you're about a year out from your effective date. That'll still give the VA plenty of time to decide your claim, and your disability benefits would still start as soon as possible. I think the other main reason to wait until you're about a year out is you want to make sure that the VA assigns you the right rating level. And I'll use hypertension as an example. Hypertension is one of the new presumptive Agent Orange conditions, but it's not effective until October 1st of 2026. So if you file a claim now, odds are your hypertension is going to get worse. And so the rating the VA assigns you today isn't going to be the rating that you should have in 2026. So again, I think waiting till you're about a year out balances all the considerations on this. Okay, so that's the first thing you can do. Just file your claim and wait for the effective date to kick in. The second thing you can do is file your claim right now and argue that you qualify for one of the hardship criteria. If you have one of the hardship criteria, then you'll get an immediate effective date for your disability. Now, that hardship criteria is if you are terminally ill, homeless, experiencing extreme financial hardship, over 85, or have other sufficient cause. Now, some of those things are pretty easy to tell if you qualify. Others, not so much. Extreme hardship in particular is one that I've been turning over in my head quite a bit lately to try and figure out what this means. On the one hand, being homeless is extreme financial hardship. So Congress must be thinking of something that's not as bad as being homeless. But still, where do you draw the line? If you have kids and they qualify for the free school lunch program because of your income level, does that mean you qualify? Is that extreme financial hardship? I don't know. And I bet if you asked 100 people, you'd get 130 different answers. Nobody's going to know on these things for quite a while. Maybe the VA will try to flesh out those definitions with some regulations, but that's not a guarantee. And even if they did, we're going to be waiting a while for that process to play out. Having said all that, I do think there are certain veterans that should go for these exceptions, either under extreme financial hardship or other sufficient cause. For example, I think if you've lost your job, if you're behind on your bills, and I'm not talking about Netflix, I mean, if you can't pay the electric bill or the water bill, things like that. If you are receiving food stamps or on some other type of government assistance, or if getting that presumptive service-connected condition is going to be the only way you can get health care. I think those are pretty good cases of people who probably fit into one of those categories, or at least have a really good argument that they fit in one of those categories. Again, time will tell. Getting back to that point about the presumptive condition being your only means of health care reminds me of something I didn't touch on a little bit earlier, and that is some of the other implications of being service-connected off into the future. So a question that I've been asked a couple of times about the PACT Act is, what are the effect of these future presumptive conditions on other veteran benefits now? I have to say, I don't know, and a lot of this is unclear. Although it's true that the PACT Act includes a very large expansion of healthcare benefits for veterans. It's also true that, like the presumptive service-connected conditions, those will be phased in over a long period of time, even longer than the presumptions. The last group of veterans to get those healthcare benefits is going to come into play in 2032. But I'll have to get into that in another video. For right now, a more pressing question is, let's take hypertension again. If a veteran exposed to Agent Orange has hypertension, and the only way they can get treatment for that hypertension is through the presumptive condition, I think they're probably going to have to wait until 2026 when that presumption becomes effective before they can get treated for that, unless they already qualify for VA healthcare through some other means. And that's probably going to cover the vast majority of most veterans. But still, there's a lot of veterans. There's a lot of Vietnam veterans, and somebody's going to fall through the cracks. And if that's you that fell through those cracks and your only way to VA healthcare is through that presumptive hypertension condition, then I would go back to this hardship condition. And I would say that's your other sufficient cause, because this is the only way you can get your hypertension treated. I don't know if it's going to work, but I would sure as hell try it. Okay, so on to the third method of dealing with these effective dates, and that is to file your claim the normal way. And to do that, as with any normal claim, you have to show that you're diagnosed with a condition right now, that you have an in-service event, injury, or illness, and that there is a causal link between that in-service event, injury, or illness and your current disability. And that last causal link is often called the nexus. There are some things in the PACT Act that are going to make this process easier, except the diagnosis part. That's pretty much the same. You have to have a doctor or other qualified medical professionals say that you have the disability. Where the PACT Act comes in, though, is that it defines groups of veterans as what are called toxic exposed veterans. I don't have time to unpack the very complicated definition of what a toxic exposed veteran is, but the highlight for this video is that if you will qualify for one of the presumptions whenever they take effect, you are a toxic exposed veteran under one of the categories that amounts to a toxic exposed veteran. So what that means is, if you've got a diagnosis, and if you're a toxic exposed veteran, then you've got the diagnosis and the in-service event. And the only thing you have to prove on the normal service connection route is the causation part. Unfortunately, the causation part is almost always the hardest part. But here again, the PACT Act lowers that bar a little bit. If you meet the criteria that you have a current diagnosis of a condition and a toxic exposure, the VA is required to give you a CMP exam. And that CMP examiner is required to consider the total potential exposures through all of your deployments. And they're also required to consider the synergistic combined effect of all of your toxic exposure risk activities. So toxic exposure risk activities is another one of those things that has a complicated definition in this new law. And I'm not going to get into it right now, but suffice to say that the law requires the VA to specifically examine that. And the examiner has to give an opinion on the effect of all of those things. All right, so is this change in the law going to turn bad CMP examiners into good ones just because they have to consider these other things? Probably not. You are very likely going to have to get your own doctor to provide his or her own opinion on this thing. And you should have that doctor include the same things, your total exposure on all your deployments. But I do think this change will help some veterans up front. I think the VA is going to get a few more of these right straight out of the gate. But I think the bigger effect is that it'll make these things easier to fight on appeal, especially if you have a good medical opinion of your own to go up against the likely bad one that you got from the VA. Okay, those are your three options for dealing with these effective dates. You can file a claim and wait. You can file a claim and argue that you qualify for one of the hardship criteria, or you can file your claim and argue you qualify through the normal service connection process. Hope you found this video helpful. I'm Al Walsh, a veteran who likes to help other veterans. Thanks for watching.